not that I should say so, because one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
There are two types of temporary provisions in Part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we are just when Mr.
Not till abrogated.
When we are putting your point, it's actually we are thinking.
I understand.
Yeah, we are just.
I understand. Yeah. This is your lordships have always done this, your lordships. This is a very fruitful debate because we all have to understand. Well, we are here standing.
And it's only in that
India.
process that we can really.
For the people of India, we're not. Well, this is not something that we believe we are totally integrated into India. That's not an issue. Well, we have said so. I mean, our constitution says we're an integral part of India. So where's the question of moving away from that? There were only two choices, Marat. We said, the Constituency Assembly said all of constitution to apply. We'd be like any other state.
But they don't have to make a constitution of their own.
Then they don't have to make a constitution of their own.
Indian constitution of best.
Once again, they don't have to make a constitution of their own. The Constituent Assembly would say, we integrate into India. We're part of India. We're like any other state. We don't need a constitution. And all those lists will apply. That power is there. So why was it called a temporary provision? Because that had to be decided by the Constituent Assembly. And then you interpret the terms to find out how that power is to be exercised. Because it was unlike any other state. The residuary power was always with the state. In the Delhi Agreement in 1952, I haven't reached
370 came in with the original constitution.
Yes.
But is there anything in the Constituent Assembly debates which throws lights on why they introduced it?
I'll do that straight away. Yes, I'll give your lordships that. Exactly what I'm saying is what they said. We know your lordships elicit answers in order to find out what we wish to say. Not that your lordships have ever decided on one way or the other. We always do that, and I've seen
the last word is said in a matter, Mr. Sibal. Everything is open.
When the printed word comes, that's the last word.
Yes, I always felt, Mr. Sibal, the judge is very quiet. There is a problem.
That's a real problem. It's a real problem. Which we face.
Actually, Mr. Sibal, there are times when you start dictating a judgment, you start dictating it with a certain...
And then you change your mind.
And you start dictating with a certain conclusion in mind, because that's what you have formed. When you start dictating it, then you realize that your line of reasoning is wrong, because, when you dictate, the logical syntax has to fall in place when, you are engaged with yourself. Then you realize, no, it's not going to fit in like this.
Quite frankly, Miller, then I'll be honest, when I looked at it myself, I asked this question that your lordships is asking me. I answered myself that question. So clearly, Manoj, clearly, it gives you an indication why it was interim. It gives you an indication why it was temporary. Because there was nothing in place. Legislature was not working, Constituent Assembly was not in place, and the will of the people had to be taken, which was reflected in the Constituent Assembly. Therefore, it was temporary. And therefore, 370, Manoj, now remember this. When 370 is enacted in 1950, at that point in time, nothing is in place. And yet in 373, they say, you will have to get the recommendation of the Constituent Assembly. That is, dehors the Constituent Assembly having been formed. Dehors its constitution. Why would Manoj, the Constitution say that? The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. Well, what can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to clause 2, not with reference to clause 3.
Yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm saying I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir. But that cannot be a permanent feature of the constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. I mean, we, in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our Constitution that it will be constituted, and the ultimate authority of abrogating 370 will be left to the Constituent Assembly. And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass on. Absent that, it can't be done. That was the understanding of the lawmakers, of the constitution makers of India, of the Constituent Assembly. That is why it was put in. It was not a temporary provision in the sense that it had ultimately 370 had to be abrogated. That's not the meaning of the temporary provision that we're talking about. In any case, Malaj, a heading of an article can determine the content of the article. Content of the article is clear. So, Malaj, the government of the day was staring at the provisions of Article 370. And according to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said it was tossed out of the window through a political act, not through a constitutional act. Such a political act cannot be determined by the Parliament of India. It's not in the remit of the Parliament of India to take a political decision to abrogate 370. And I will demonstrate as we move along, well, how it was done and in what manner it was done. Nobody can deny that the people of Jammu and Kashmir are with the Union. It's an integral part. Nobody can deny that. But there is a special relationship. There is a unique relationship which is engrafted in 370 itself. You can't jettison that except by following a process which is ordained by law. Some of your lordships asked me on the Constitution, I wanted to just mention this. This is the debate. However, averse to President exercising the power to proclaim a general emergency on account of internal disturbance, which ultimately your lordship knows was also taken out of the Indian Constitution under 352.
At the relevant time, it was there.
It was there at the relevant time, but the state said we will not allow it to be exercised.
I'm just trying to think aloud. At the relevant time in 75.
Yes, it was there.
It was there.
It was very much there.
And this, through some subsequent orders, it equally applied to Jammu Kashmir at that time.
That's correct. That's correct. Absolutely right.
This summary, which my friend was doing, Delhi Agreement summary, this seems to have been taken out of this book, and Justice A.S. Anand.
It's not publicly available, but Justice Anand has that one.
Constitution, it's published. Constitution
No.
Jammu and Kashmir.
The agreement is not publicly available.
So he has given the authoritative statement in the sense, what is it? What does it imply?
That's correct. This is also part of the compilation, which is before your lordships.
That's what we were reading.
Yes. So, but what happens ultimately is that Parliament exercised the will of the people of Jammu and Kashmir when they abrogated the article. That's what happened. They took upon themselves the constitutional responsibility of saying that we are now the legislature, we are the Constituent Assembly, and we will exercise the will of the people of state of Jammu and Kashmir to say that we abrogate 370. In essence, that's what happened. Is that possible constitutionally? Is that envisaged by 370? Is this not an exercise of political power without reference to 370? And can such a power be exercised in the manner in which it was exercised? That's a matter of procedure.